Bizhiw, Kekek Indigo, Benesin Guime, Bizhiw and Dode, Mekanakuing and Dunjaba, Niman Wenda Mayan Mano Gum, Chikagi doing Anishinaabe na Konagawin. So, my name's Kekek. As said, I'm a professor at the University of Montana, run the Indian Law program, and we're going to talk a little bit about Anishinaabe Law, how that fits with the rights of nature. And so the first part, I'm going to give some background and thoughts about what is Anishinaabe Law, how is it, what are some principles to think about as the community's developing what they understand the core to be, what have other communities done, and kind of where do you take that, and then how does that build on the deeper structure. And so one of the things to think about as you're engaging with this conference, the principles of saying, how do we define our law? How do we define our understandings of what it means to be law, what it means to be Anishinaabe, is really the work to do it, to engage that process of understanding, the law, and understanding what it means to the community, to the village, to the nation, so all the Ojibwe tribes combined collectively, so really engaging that. And if we understand that law is dynamic, it transitions, it changes, it morphs, so should our law do the same thing. So it's okay if we say this is our principle and now that has evolved into something else, because it can be fluid as well. So as we're engaging it and get better understandings, it can be fluid. So if we think about it at the grassroots level, it's okay to engage that, make mistakes, changes, say this, change it to that. Also, who's engaging? It comes from all level. Not only can the courts engage principles of the law and say we're bringing it in, practitioners can. If you're litigating a case, if you're bringing a case, community can, tribal council can enact it. There's all kinds of layers where you can, really engage those aspects of what the law is. And so it takes really the collective. So if only the court is doing it or only council is doing it and the other aspects of government, are disassociated, you're going to have more effect the more everybody's engaging into the different aspects of it. So that's something to think about. So as we start, we got to realize that our law, if we want to think about how law is developed, tribes as political entities, we have a different philosophy, right? So what the settler colonial philosophy is, how their law is understanding, from an inherent principles, a lot of times our tribal laws are different. And so we have to understand that they may be the same, they may have aspects of similarities, but they can also be very different. But the essential source of our law is typically traditional law. So a lot, as Tom talked about, traditional law forms the basis of what is the source of our inherent law. And there's different layers that I'll get into as to what are those aspects of traditional law. So someone we'll just refer to it as tribal law, tribal customary law. Some will use traditional law because, as referenced earlier, sometimes there's different trigger words in what you're using. So someone may go different than traditional law, say customary law. Some will just use tribal law, all those aspects. So, even though we have this rich body of knowledge, a lot of times it's missing from our modern day tribal governments. So some tribes have been really successful in implementing those principles, but across the board from Anishinaabe governance perspective, a lot of times they're missing in our tribal court applications, they're missing in our tribal council applications. That is starting to change. Specifically, the Michigan bands are doing a really good job at revitalizing some of their Anishinaabe law principles, and they're at the forefront of really engaging that, which I would advise any of the bands, whether Minnesota, Wisconsin, North Dakota, even the Montana across Ojibwe country to say, hey, let's look at what they're doing because they're doing a really good job at least in engaging some of these traditional law concepts. So what we got to remember is like this quote here, what we were given is still here, right? We still have those that know our teachings. We still have those that know our traditions. And so we can access those aspects, right? So it's not gone, it's not forgotten. It's still here and it's still accessible. So if we think about that as our stories create that collective body and those principles that bring value to our life, that bring understanding to our roles in society, our roles in the community, and that creates our embodiment of what Anishinaabe Law is. And that all stems from our teachings, our stories, the oral tradition that's brought forward. So one of the ideas of explaining that is in Donna Kubajigun. So some would say Kubaday, but really that idea of your great-grandparent. So this is a painting my son made trying to explain the concept of 7 generations, right? So the same word for great-grandparent is the same word for great-grandchild. And so it links 7 generations. So a lot of times as Ojibwe, when we think of 7 generations, it's that link. And they say that's almost like a DNA cord, that ancestral cord with the pull from your great-grandparent to your great-grandchild. And they're like pulling, like the young ones are pulling us along and pushing us forward while we have that link of knowledge. And so to understand that as a connection, as part of our law and our systems, and that ancestral link helps us understand that connection to story, place, and how it's perpetuated through the generations. So with that is an importance of language. So a lot of times when we think about, are we engaging law? Are we using English concepts or are we using Anishinaabe concepts? And so part of the importance of language, of being it embodies our philosophy of the world different than what we can explain in English. And so I had this conversation once when I was working at Great Lakes Indian Fish and Wildlife Commission, and we started putting language within the code and the management plans. And at some point the lawyers were like, hey, we can't do that because what happens if there's a dispute on what that word means or that concept means? And like, we won't be able to interpret it. I was like, well, one, if the lawyers have to take a back seat and bring the elders forward to explain a concept, that's a good thing. 2, if we're having a dispute in the language about the principles of a term, then we are successful because they're actually engaging those concepts, ideas, principles, and we're doing what we set out to do. So that would be a valuable thing. So to think about how the language is important as a spiritual gift, how we bring it forward. So as we're enacting our laws, as we're incorporating our laws, using those principles, also with the understanding that, law can be dynamic, so we're not binding it. So some of the fears, if we codify like an Ojibwe term or a principle or a teaching, then does it get frozen in time, right? So the idea is sometimes if you use the values or different ways, it can be more dynamic than that. So with the understanding that we can be dynamic and it can evolve into what our understanding is, just like the law evolves, whether it's a trust duty and how that evolves in the understanding, so can our law and our understanding if it comes from traditional law concept. So also another importance of language, it connects the past and contributes meaning to our existence now. So in our group, we talked a little bit about the importance of our youth and how our youth involved, how are the elders involved. And so part of that is creating that connection. So if we think in Donna Kubajigun, connecting those generations, that can be done through the language, through our sound. So also the idea of each word, so each word, when we think of the words and how they're broken down to the root, to have that, I was told at one point that, like a lot of times, even with our Indian names, that they're embodied the basic story of that name is embedded within what that word is for like our Indian name, and how, like even when we hear it, we begin to think about the teaching of what that is and what's the story behind it, what we've heard. And so it's like a triggering device to understand this greater context by just hearing the concept as you break it down. So the same thing works with our law. When we're engaging these principles and terms with our law, we begin to understand this deeper meaning of what our law is and how we understand it. So also, if we think about our connection to stories, here's a couple other quotes about importance of language. So our Adazukanan, so the difference, the understanding what those stories are, how we bring them forward. Then you also think about, so are we accessing, those traditional stories, the Debajimoan, those like lifetime people stories, how they embodied, and then how are we engaging them, right? And then so some talk about, well, how are we engaging these stories if we're engaging our law? What happens if we can only talk about them in the wintertime? Can we only prosecute in the wintertime? But it's really the teachings and the principles, right, that are pulled from those stories. And so that's a way to say, like, they're grounded in these contexts and we can pull them forward to utilize. So some have also said that those stories, our Adazukanan, create our collective memory. So like in those stories is the collective memory of all of our people, all of our communities. And so like that's webbed together. It's even through the retelling, right? So as you hear of, a wintertime story that grandpa told, that someone else is telling, and then you sometimes add your local twist or your local community thing or family thing. So each time it's retold, it's incorporating some of that local, collective, individual memory that's getting embodied within what those teachings are. And that's important when we think about pulling from that for our sources of law, because the more a teaching or a principle is common knowledge, that can be better understood as being tribal law and having force. So a lot of times sometimes constitutions, sometimes their choice of law codes, it's going to say at the beginning, this law will be incorporated pursuant to the cultures and customs of the band and the United States Constitution, and lastly, the state of Minnesota, blah, 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 right? So then you're like, what is culture? What is tradition? And as you're pulling that, it sets that foundation. So that also becomes important when we begin to talk about the land and our connection to the land and how that is embodied in our law. So one of the ideas is how we define ourselves as Ojibwe Anishinaabe. And so if we think of, I know there's a lot of understandings, what is an Ojibwe? Are you a pucker moccasin? Are you not? But a lot of times we talk about our sound, getting way with non, right? Our collective sound, and Anishinaabe being pitiful man, the one who was placed here, spontaneous man. However you're defining it, it kind of refers to our creation story, how we were made. So collectively, our connection to place, plus our identity through our sound, defines our sovereignty. So some use an Ojibwe Anishinaabe as a word for sovereignty from an inherent Ojibwe Anishinaabe perspective, because even for creating Aboriginal rights, it's geographical place plus identity defines Aboriginal rights. And so inherent within our own understanding of ourselves creates our sovereignty and our connection and those inherent rights to the land, resources, connection. And that's partly with our connection to place, and then our sound and our connection to each other and how we interact. That was also, when we think of the flood story, so Treaty 3, when they did the Keywait and Lands case, they passed a resolution that explained beyond what we a lot of times hear about in the flood story when it's told or when it's written down. They said at some point when they recreated the earth that part of diving down created a submerged land. So a lot of times from a law perspective, like even Minnesota will say, well, you don't own the lake bed, you don't own the riverbed. So part of the idea was the story says that we have ownership over the submerged lands. Obviously we can have conversation on what ownership means. Is it like responsibilities, duties versus like dominion over, but the idea is you have this connection and a potential right and or obligation to submerged lands. Same as they said flyers were flying overhead, which created lateral airspace. So if we have the idea of who owns the airspace, that we have a story connecting that. Those water spirits, cliff dwellers, or headland and the riparian rights, so along the shores, along those areas is part of the owner. Mineral rights through those that dug into the earth. And then the runners that measured the land, right? They say the caribou went out first. It was defined the family area. Then the fox was the area for the village, the bear. Some I've heard stories where they talked about being the moose was the hunting area, and then as the wolf took off, how long is it? That was the expanse of our nation. And so all that comes to partly our responsibilities later to family, to village, to nation, to our resources and hunting areas. So if we think of Ojibwe country as it's defined on the map, which we can extend now with Little Shell and Rocky Boy, even further into Montana. But that shows the expanse of our territory. So one of the ideas for Gidikiminan, so again, we're talking about what is our understanding for like nature, for earth, like our collective earth, as one understanding. And then also that we had a relationship with the earth from time immemorial, since creation forward, right? And so in that understanding and that relationships incorporated in our term for law. So Nakonagawin is our term, what we call law. And like Harry Bone had a conversation, who is an elder in Manitoba, and he said that Nakonagay refers to pointing the pipe stem as part of a pipe ceremony, right? And so part of our understanding of law is connection with the pipe ceremony and our connection with prayer. And that also extends to why prayer and ceremony is important for the engagement of our law and how we're understanding. So this is part of the Mille Lacs case, when they had the pipe in the steps of the Supreme Court prior to Minnesota v. Mille Lacs. And so they used the pipe. They took the pipe from Lac to Flambeau all the way. They ran it actually all the way to D.C. as part of the Wabanong Run, that they ran the treaty staff and the pipe, and they used it, and they used ceremony as part of enacting, their law and their understanding of the court case. So that comes with the idea of then the great laws of nature. So what are the great laws of nature is part of our understanding of nature's own laws. And so one example is that they said the Great Spirit made the great laws of nature for harmony, right? So if we think of Bimataziwin, part of the idea of what is harmony, and they govern the movement of the earth, the sun, the moon, the stars. So everything's governed inherently by these laws of nature. Also, like all the elements, rock, fire, water, like how the systems work. So like that's inherently built into like the great laws of nature. So everybody's ruled by it. So that's when we think of inherent law or like earth law, and it has no mercy. Like if you violate it, there's consequences, period, right? And so that's why we have ideas, understandings, ceremonies, responses, like, hey, I violated this, have pity on me, so I like can go shoot a deer tomorrow because that one was wasted, right? And then how do you make amends for that? And so part of it built into our systems is the ability to make amends for violating, earth-made law. So when we think about moving forward or the rights and nature laws, we come from this category, mindset. And so part of that is our treaty with creation. And so part of the great laws of nature is that of those original treaties with the animals. And so the idea was, as always, Anishinaabe were having a hard time. Animals had a great council. They said, how do we pity them? How do we take care of them? And they agreed to help. So some say that was the origins of our clan systems. The first time they're like, I will accept them, like the Bizhiw. I accept him as a Bizhiw, and I will teach them how to live and how to love through me. That's part of that first treaty. And so when we think about treaty rights and treaty obligations, we got to go beyond what that first treaty is and carry that forward. So as our ancestors were engaging into treaty councils with, the United States, or Britain, or all the aspects, they had their first treaty in mind, bringing it forward. And other tribes had the same idea, like the Lakota, I think they call it Tinta Winta, as their treaty with the universe, treaty with creation. And so it's a similar idea that tribes had these responsibilities. So with that is our different categories of law, right? So Manadu and Nakonagewin is like spirit-made law, creator law. Gagige and Nakonagewin is like eternal law, the rights, responsibilities that are inherent in our belief systems. Then Gete and Nakonagewin is traditional law, those old systems. So that's where we're pulling from the stories, the life stories. And then Zagamak and Nakonagewin is natural law. So we talk about and all these collectively make up that idea of the earth-made law. So part of our ability to exist within creation then is part of balance. So we talk about harmony, and for the Anishinaabe, it's Minobimataziwin. So to live a good life, to live in a good way, part of that's balance. So again, it's not about the idea that there was never imbalance. There's the idea that if something was put out of balance, how do we then restore it? So that's the same idea with like conflict. If they had conflict, the idea was to resolve the conflict to make it better, and then to move forward and restore the balance. And so if we think about how we engage in our resource application or like developing our law, it's not, we talk about, is there no extraction? Is there no use of resources as commodities? I think that's something that everybody can engage in a dialogue about. But again, it's about balance. How much is too much, right? How much is not? If you have wild rice for sale, at what point do you be like, well, this is how much we have set aside for that, and this is how much for community and those things. Those are all conversations, because it's not that you can't do any, because some people may need it and that's their only way to obtain it. But again, it's about balance. So that's the thought. And other tribes the same way. So as Professor Sose will likely talk about with other tribes, like with the Navajo, Hojo is the center for their idea of, balance, understanding that relationship. Wolokota, as referenced by Tom earlier. So like a lot of the tribes use that idea of harmony and have developed their legal systems based on that principle. So by bringing that into our courts and our legal systems, so it adds context and really like that cultural component to what makes our tribal courts tribal, right? Like inherently tribal. It's part of the idea of incorporating our law, incorporating our understanding of Bizhiw, right? So not like as a system of retribution, like, oh, you violated the law, like, let's send you like 60 days in jail. Well, the idea is, how do you restore harmony? Maybe that's not the appropriate punishment, which is what we're learning now with some of our, drug courts, other courts that are like doing really the restorative justice type stuff, is really restoring harmony and getting back to that. So it's important to think about as we develop our law to use our principles. So with that, you get the idea of the 7 grandfathers' teachings. As principles, honesty, respect, wisdom, as we bring them forward, we can utilize those as core values that help us understand our responsibilities. And there's a nice quote from Larry Steelday about the use of the grandfather teachings. So we also have the idea of Anishinaabe. So if we think of custom, belief, culture, however you want to define it, but the idea as another bedrock principle to think about how that's being built in. So I know some of the cases, specifically Sault Ste. Marie tribe had a recent one where they talked about the importance of Anishinaabe as they're implementing a child welfare matter, and that they needed to revitalize this idea and their responsibilities to this child. So they were bringing that forward as an element of traditional law, even in like a child welfare matter. And that's important because if we think about our importance of culture and harmony, and it's all based upon kinship. So when we begin to talk about jurisdiction, then we're going to understand the importance of kinship responsibilities. And so part of that is embodied in our understanding of relations. So in Dinawe Maganadok, in Awendiwug, the idea of like having relationality. So how are we connected? How are we related, right? So is it blood related? Is it clan related? Is it like Wee or ceremonial related? Is it like adoption related? And so if we think of the importance of our kinship systems and networks, that's what bound together the bands in our governance. And when colonialism came to destroy, our governments, it was through the destruction of our kinship networks that they did it. So as we develop systems to rebuild it, we got to think about how are we rebuilding our clan systems, how are we rebuilding our relative networks, because that is the core aspect of jurisdiction. And so if we think about the limits on the rights of nature or how we are applying jurisdiction with any enactment of Anishinaabe law, relationships is key. So the other aspect that was on there is that it's reciprocal. So in Awendiwug, we're talking about the reciprocity, like a mutual obligation back and forth. So that becomes important when we think about Minnesota, when Wild Rice is suing Minnesota, and they're like, well, we have a mutual relationship. They also have a relationship, which then allows the potential for them to have consent to jurisdiction because of their understanding of that relationship. So keep that in mind. So also the importance of how we governed so if we think about our kinship systems that were broken or like tried to be dismantled. So we had different ways of how we were supposed to act towards each other, right? Like you had responsibilities, you act to your brothers and sisters, your parents, whether it's aunties, uncles, how they were just, these are considered my mother and my dad and my same idea, versus my cross cousins versus my parallel cousins, and each one had responsibilities. Well, that was mirrored. If you think about our relationships with the earth, we have kinship terms for a lot of the earth, and our relationships and how we governed was similar to that, right? So how we treated grandma is the same as how we're treating, grandmother earth or, the sky. And so like they said, how we regulated each other is also how we regulated wild rice. That's how we regulated our resource. And so they were mirrored in parallel. So if we think of the rights of nature as a living being, as an entity, our regulatory scheme is already built into our kinship structures. So if we think about the clan system, another idea of relationships, how that's governed our system. So a lot of times we'll say clan system was a traditional form of governance. I think it was a little broader than that. Our clan system, ingrained with our kinship system, created our traditional form of governance, because how we were married in and who those other aspects, which is like it was almost, they were linked together. And so as we bring that forward to understand our connection with the Treaty of Creation, our rights to the laws of nature, that's all embodied with our clan responsibilities. So if it goes back to like, hey, I take this individual to be a Bizhiw, because they don't know how to act, so I'll teach them, and part of our responsibilities going forward. Then how do we treat each other, right? So how are our clan responsibilities? So if someone's from Bad River and they're coming through here and they're your clan relative, like what are your responsibilities? Put them up, feed, host them, house them, and then what happens when they're like, hey, let's go shoot a deer together? Like what are their territorial obligations and your responsibilities with the local bands? All that's built in how we enact those relationships. So if we think of modern day Anishinaabe law, that's built in to our responsibilities to how we interact with each other, which also gets to jurisdiction over each other. So the other aspect, Anishinaabe King, our traditional territories. So our clan system united our territories. And so when we've seen the big map from Michigan basically to Saskatchewan, North Dakota, Montana, that our territories were governed by each of the local bands, those family units, and they were connected through the clans, right? And so that's what created that broad alliance across the spectrum. And so it's important as we revitalize that is what is our responsibilities. So our collective sovereignty versus our individual sovereignty and our responsibilities that go with that. So again, also our clan's important when we're thinking about our sovereignty and our understanding of sovereignty. So if we think about geographical place plus identity, and then our role connecting to our clan, which is a lot of times why we always introduce ourselves. Where are we from? Our connection to place. Who are we? Our connection to our identity. And then who is our clan? Our connection. So also, the idea of Ogama as a leader, boss, chief, right? So if we think about who our chiefs were, what were their responsibilities, and that gets into the idea of Ogama literally means those that I am responsible for, right? And so the idea of Ga'eji Ogamawat is to carefully act in a way that recognizes those I am responsible for. So some argue that this is another word for sovereignty, but also duty, right? So if we think of trust obligations, trust duties, that this is our principles to be like, again, as a reciprocal relationship. So who are you responsible for? And as a leader, are they appropriately acting according to their responsibilities? So it's interesting if you think about how do we regulate our tribal councils? How do we regulate our leadership? Are we holding them accountable to their obligations and responsibilities? And this is a principle that in some ways, like Grand Traverse, they had a case where they're like, no, that leader was acting outside their responsibilities and their obligations, and therefore, here's how we're going to, issue this opinion. So it's something to think about as you're developing your law and moving it forward. And what does that mean for sovereign immunity? Because the sovereign has immunity. So usually a tribal leader also has immunity. There's this case called Ex parte Young that they're like, well, you don't have immunity if you're acting contrary to the law or outside of your realm. So here the idea is, well, if you're acting outside your responsibilities, then your immunity no longer exists. Well, if it's a reciprocal relationship, then that's also those other obligations. So if we have a relationship with the state of Minnesota, then the state of Minnesota also has to act according to our responsibilities, which also means if they're acting contrary, their sovereignty and sovereign immunity is potentially waived. So as we referenced, the idea, that's what they argued at both the district court level and the 8th Circuit, like, hey, we have sovereign immunity, you can't sue us. And they're like, well, maybe under Anishinaabe Law, we could sue you because you acted contrary to the law of the land, the law of creation. Something to think about. So again, we talked about ceremonies being important. They were embedded in the idea of our treaty councils, treaty negotiations. So here's a picture from the 1837 treaty where they're like, we're going to have a feast and dance in your honor, presented the pipe of peace. So we have examples from our treaty history that we incorporated ceremony within, our law and legal structure and negotiations. So the other part is to think about how that carries forward, in modern day negotiations. So if you're talking about free and informed consent, and, do they start the meeting off with the pipe, or do they start the meeting off with the drum or a song, or those aspects, and how it changes the whole tone in the negotiation, because you're incorporating this whole spiritual component that's, becomes present. So if we get into the idea of laws of nature, then obviously, because we have this relationship with the great, with the earth, what is earth law? The idea is the earth is living, right? The same as any other being, it's animate. So that's embedded within our understanding of the universe as Anishinaabe people. What is animate, what is inanimate, how you get these deep-rooted understandings of things being alive that in English wouldn't be necessarily alive. So to say that the earth has agency, well, that's embedded in our philosophy. So generally, if we think about the ideas of the rights of nature, so the movement says Earth's natural ecosystem has an inalienable rights, right? And so part of our understanding for inalienable rights was the title, Bizhiw gonna wa bundi young. So if you look in the Ojibwe legal dictionary that a number of Manitoba Council created, that's the word they use for inalienable rights. And so those things that are not capable of being transferred or surrendered. And so that's, if we think about that, and what is our connection with nature, like we can't, our obligations can't be given away, they can't be surrendered. We have these inherent duties. So if we think about how the, part of the rights of Menomin, how it was enacted. So again, they were trying to balance the rights, the property rights with human beings, the rights of human beings. And which includes the earth as a living entity. And so what is the landowner's rights associated then with, the individual's rights? And so that's been the rub of American law forever, the rights between the individual property owner and others. So part of the law or the declaration says, wild rice has the right to exist, have habitat, participate in the earth community. So that's an important aspect to think about its place. What is it being protected? Which then goes to how do we measure if it's violated? So obviously a number of tribes have enacted their rights of nature. Here we're talking about the rights of Menomin, but then you get the rights of Weroy with Klamath and the Yurok. You get the rights of salmon, the Sauk, Seattle, other areas. So here are the two resolutions, which I'm sure you're all familiar with. Both the White Earth Band and the 1855 Treaty Authority enacted their resolution. So it encompassed both on reservation and off. And so that was part of the dispute as to at what point does your jurisdictional boundaries extend to. So a lot of times the standing is the issue. Like, do you have the right to bring a claim for your non-tribal cases? So standing isn't an issue because under tribal law, we're like, yes, Earth has agency, that's easy. Here it's a jurisdiction, which is where we get the idea of dispute. So obviously wild rice is important. Wherever you find Ojibwe people, you'll find wild rice. Even in the Turtle Mountains, because they threw some out there and planted it. But actually they said that you would do it because people would drop it, eat it, plant it, seed it. So wherever you find them, because they would plant it. So special gift from the Creator. The resolutions acknowledge that. So the important aspect is a tribal framework. So if we take all these codifications, it creates this interesting framework that other tribes can replicate. So if they want to create rights of fish, rights of walleye, rights of a lake, it creates those boundaries and those framework for enacting future delegation. So one of the successful thing was the declaration of the rights to exist, right? So if we think about how we talked a little bit of UNDRIP and what the idea of a human right. So if you're extending this human right concept to the earth, that's like pretty successful in that enactment. Also establishing that relationship that the tribe has with their resource is also important. So through the enactment saying we have this connection, we have this understanding, which really goes to the core of the spiritual cultural component, which can be useful later when you're fighting over jurisdiction. So a lot of the ordinance talk about the rights for members to engage. So again, we're talking the individual right. So they have the right to harvest, protect safe seeds for Menomin. In Klamath, they had the right to use the Klamath River. And then the rights of salmon, they had the right to harvest salmon. And so part of those responsibilities was acknowledged. They also acknowledged the right of sovereignty, right? Both individual and collective rights. And then the idea of penalties, which was interesting. So what is a violation? And then what are the penalties for a violation? What's an offense? So they're guilty of a maximum fine allowable under tribal law. So you think about what is that? Is that an individual like penalties? So under Tribal Law and Order Act or the Indian Civil Rights Act, is that limited to your violations? unless you look at like some of the habitat and the bigger things. So if you look at what happened with Enbridge oil spill at Kalamazoo, right? It cost them $1.2 billion for the cleanup and to make the reclamation. And Enbridge likes to take people out, look at our great job cleaning up this ecosystem. But if you look at, and if you talk to any of the Indians in the Kalamazoo area, they're like, there's still no wild rice growing there, right? And so like, have they even finished fully restoring the thing when it was chock full of wild rice, now it's gone. And they have what looks like healthy habitat, no rice. So the other aspect is who speaks for the resource. So something to think about. And I know with the rights of nature, like they created another council later to be like, who is that voice? But something to ponder as we're saying, who's listening, right? So if we're like, hey, the earth has agency, the earth can tell us things. Well, who's actually listening, right? Who's sitting out there? And what does it take to do that? And, you know, so sometimes are we actually listening when we're engaging in the creation of our law and enforcement of our law? So that's one of the thoughts, to ensure that you actually have the protocols in place, that someone's paying attention to what the earth is actually saying. So what is that rice bed telling us? What is the earth telling us? What are we protecting? So one of the ideas for that, Gidawi Dabama Gidikiminanje Nanaganawenji Gewad. So the idea of like sitting there, participating with the earth and pondering, right? And so like who's engaging in that pondering thought? And then those are the designated people to say, hey, this is what we're thinking about. So if you think about, and Tom probably remembers, so like back when they were putting the, reroute to Highway 55 in Minneapolis, and they had the oak trees, and they were like, hey, they're gonna cut down the oak trees, big old dispute. And they had ceremony, and ceremony said, it's fine, leave it alone. And people were like, what? We can't leave it alone. What happens if the resource tells you it's not a big deal, I'm okay? You know? So part of the listening is important to think about, what are they actually telling us? Not as humans, what are we like thinking they should be the right thing, but what is they actually telling us? So one aspect about that is like the idea of a permit. So the question with the resolution was, they're basically any tribal member can enforce these provisions. And so one idea would be that like whoever is responsible can actually be sanctioned by the tribe, the entity, whoever, the regulatory body, natural resource department, to be like, hey, you're the one to enforce this or to engage it, like you're designated. So that could be a permit, could be a resolution, anything authorizing it. But the benefit is that you're not having a blanket authorization, but those that are delegated with that responsibility, then they're making those decisions who's speaking on behalf of the resource, those that have put in the time and our work. So one of the other aspects was tribal authority over law enforcement. So like the rights of Minoman prohibited law enforcement from arresting or detaining anybody enforcing the rights. So we know from Nevada v. Hicks that tribal authority to regulate a state officer enforcing state law is not an essential to tribal self-government. That's what the Supreme Court said. So that becomes a hard barrier to be like, hey, we're preventing the state from creating these authorities. But the idea is preemption. So if we know from the treaty rights context, a state is preempted from enforcing state law against the tribe if the tribe is properly implementing its own regulations, right? So part of that is using a preemption analysis rather than a regulatory analysis. So also the territory and jurisdiction, where does it apply? And so if we think about jurisdiction from an Anishinaabe perspective, the core goes back to relationships. So who are those relationships? What are our kinship networks? Who are our clans? Who are our adopted relatives? Who are our ways? And all that begins to define our relational network. Who's married in, who's adopted, you know, who's even been like accustomed to being present, and who are engaging those ideas. So if we think of jurisdiction from a relationship perspective, that's part of the core of asserting our jurisdiction. Second, if we think of Gidikumenon as our earth, our territories, and so territoriality matters. And so our primary obligation over our territories, you know, that maybe the village had, the community, and then the band, that's then, you know, because each of the bands have their lines, like at what point does White Earth stop and Red Lake or Elite start, right? And they were pretty known, like this is kind of ours, we may share this, and so how you're applying your law to your territory matters. That also matters as part of the treaty relationships when they created the treaty. And so that's the idea of Manadum Mazanaigan, that's what a lot of times they called the treaty. And even with that, there was a lot of discussion about, because when they created our reservations, they created permanent homelands. So even the discussion when we talk about now water rights, the right to homeland, even with the Navajo case that was just decided. But the idea was, part of the idea of permanency created this primary right to have jurisdiction over that territory. And so even with the idea of the deeds, a lot of times they're like, well, you got an allotment or you got a deed. And so some of the work, they called them Zungi Mazanaigan, like this strong paper. And they said under the understanding was, this makes my connection to this place even stronger and therefore nobody can separate it. And so that came out recently in the LCOV Evers case, where they're like, hey, under the 54 treaty, like we have this permanent homelands, we don't have to pay taxes. And that's now butted up against your Cass County case that says the Nelson Act says, you know, like you have to pay these taxes. So now you're gonna get a battle between, which would be interesting if Fond du Lac or Grand Portage bring it, between the treaty and then between the Nelson Act. And then there's the potential to overthrow or throw out the provisions of the Nelson Act, because even in Cass County, the Supreme Court didn't really analyze the provisions of the Nelson Act because it was more complicated. They were like, oh, in County of Yakima, they said a general allotment, you know, you lost jurisdiction and we're gonna apply it here too. And so that'll be interesting moving forward in how you're understanding what your connection to place, homeland, even at White Earth being like, hey, we want this to be the homeland for all the Anishinaabe. Like you have the argument that this is the place you have jurisdiction, how that's set up. So as Tom talked about the Montana test, so under federal law, there's you have consensual relations, which a lot of times, that's why relationality matters, but relationality based upon our kinship networks. And then a lot of times they call the second exception the direct effects test. But what was missing in like the opinion with Minoman v. Minnesota was there was no cites to any tribal court opinion, right? It was all under federal law. They were all applying the Montana test, not based upon Anishinaabe law or Anishinaabe principles. And there's a number of cases that were tribal court opinions that became federal court that really engage when you're talking about a spiritual or cultural resource, the importance of it and how that actually meets the direct effects test, right? And so the idea of having any impairment to wild rice is a violation of natural law, right, of spirit law. And therefore, there are consequences, even if us as Anishinaabe don't do it, if we don't protect it and uphold our duty and responsibility, then we have obligations otherwise. So, in closing, I guess, the idea is that we begin to talk about these concepts, how we can bring them forward, further engage, what are our duties, obligations, and spark that dialogue.
So here's my thought. First of all, that was awesome, and I'm exhausted. That was so much information, and thank God we're recording it, right? Because we're going to be able to get a transcript and have some analysis of it, because we're going to have to pay some attention to everything that you said, so I appreciate that.